Calling the matter of Dean Oberhue versus Julie Perez.
For the record, this matter is before the court for continued pretrial conference, as well as a number of motions followed by the. I'm sorry, we just lost Ms. Perez. It's also before the court on various motions followed by Attorney Kirschbaum on behalf of Ms. Perez. Present this morning is Attorney Timothy Churchill representing the plaintiff Dean Oberau. Mr. Oberau appears to be present with Churchill. In addition, Attorney Marianne Kirschbaum is also present. Good morning, everyone.
Good morning, Your Honor.
Good morning.
We're going to wait just a minute for Ms. Perez. She was here, then lost connection.
Your Honor, she's in the conference room of my office where there's staff assisting her, so she should be right back on.
Thank you. Ms. Kirschbaum, Mr. Churchill, the court's understanding is that the parties will mediate with Mr. Attorney Godfrey this morning. Is that correct?
It is scheduled for 9 o'clock this morning. That is correct.
Okay. Mr. Godfrey alerted the court late yesterday. And so the court is inclined to defer any addressing these motions until such time after mediation. Let's see if we can resolve the whole everything. Mr. Godfrey said he would be available, even though it's scheduled for 9 o'clock. He'll be scheduled available shortly after 8:30.
Your Honor, I would normally not make an objection to that, but Your Honor, I really need to argue my motion, and my motion argument is extremely brief, Your Honor. There is no way, because of the events that have happened that were clandestine and underhanded, I don't have the information, all the information to mediate this case. And I am respectfully requesting, Your Honor, to give me 5 minutes so I can argue. The
court received a 52-page response from Attorney Churchill late yesterday afternoon. I have not even looked at it yet. So, of course, not going to entertain the argument, make a decision without reading all the pleadings. And your motion consists of significant, I haven't counted the number of pages, but it's significant. So the court is not prepared to make a decision on this motion this morning, Ms. Kirschbaum, with all due respect. So the court's going to defer that. I will, in the interim, I will review the motion and the response of pleading. Did you receive a copy of Mr. Churchill's response?
Yes, I did, Your Honor.
It was on my desk this morning. I was gone when it was received, close to 3 o'clock yesterday. So the court is going to direct the parties to zoom in right now to Attorney Godfrey. You can raise some of these issues with Godfrey, and that's certainly relevant if you want to address some of these issues in mediation. But let's see if we can just resolve this divorce action.
That's fine, Your Honor. It's interesting that the response was filed on the 11th hour.
I got it on Wednesday at 3 o'clock. I've spent Wednesday evening answering it. Was typed up Thursday and wasn't typed up till a little afternoon. It was a very lengthy motion that required a significant response. It was postmarked the 15th. It was received at our office on Wednesday at 2 o'clock with the mail.
It should have
let's go to the mediation. Let's go into mediation with an open mind. Everyone, including counsel, let's go into it with an open mind. The best interest of parties would be served by them reaching their own agreement this morning. They are familiar with the assets. So let's give it a try this morning. So I'm just asking the parties to zoom in here, subsequent after you've exhausted all efforts with Mr. Godfrey. I'll be here till 2:30 this afternoon.
Okay.
And Godfrey said that he would be, don't need to wait till 9 o'clock. So I would say just hang up here, zoom into Godfrey, and he'll be available this morning.
Okay, very well.
Thank you, Your Honor.
You're welcome.
This is my mom and me. We flew into London, then took the train to Paris, then flew to Florence and down to Rome, and flew home from Rome on Saturday.
Well, that is quite the trip.
Yeah, it was pretty cool, once in a lifetime kind of thing.
Yeah, it's awesome. But a lot of good eating the whole time.
Yeah, for sure. Fortunately, we're getting like 20,000 steps a day to offset that.
It's balance.
Yep, you got it. How are you, Sarah?
I'm good.
Good.
Hi. Oh, you got an office?
Yeah, like in a little room.
Oh, nice.
We don't
I was
use
gonna
to see
have to go-
patients.
I was wondering if like you were have to go to your car or something. I was like, oh, that's cool. You want to see Buddy Boy?
No.
Okay.
Not right now.
He's just like gnawing like crazy on a bone. It's like, bro, shush. Oh. Do you have a lot of patients today, Sarah, or
No. It's pretty short schedule today.
they might get out early?
Well, that doesn't happen, but it'll just be a little bit easier because we won't be as busy.
It's probably for the best.
Yeah.
So you heard what she said about it'll be like take care of everything day, but it'll beginning of the year just for the taxes. So
So it won't be finalized today. It'll be in January.
Yeah,
Just for-
you guys, in order to file your taxes together, you guys have to be married on the 31st of December.
Yep.
That's what I thought. Okay.
Yeah, and because that's what Kelly told us when we did taxes this year, and we told her about what was going on. So I'm like, oh yeah, exactly. That's
Yeah,
We're
so
just
we'll
gonna-
send it over first business day that I'm back after the new year.
okay.
And then you guys will get true copies. That means a copy with a raised seal on it, so it'll be official.
Okay.
You getting that haircut today?
Probably not, but it's definitely moved up my list of things to do.
Sorry.
No, every time I'm home, my parents are like, "You getting a haircut?" It's like, it's you have a free haircut, right? I'm like, I know. Why wouldn't I not procrastinate about something simple like that? I did wet it at least, and try to
At least you're aware. At least you're aware of your procrastination.
And I told them like, hey, I came to a realization last night and like admitted out loud that the mustache is starting to turn gray. And my mom was like, honey, it's been gray. I'm like,
You were in denial.
yeah, I had like blinders on, I guess. I don't know.
Welcome to your mid-30s.
I'm not to mid yet. Approaching mid.
Almost.
Let me hold on to this, okay?
Okay. Okay.
Think about not cutting the hair or shaving. Just go.
Now it's
Yeah,
like just
see how
to
rugged
fall
we
down
get.
and break anything. That is the goal for today. Okay.
Just yeah, fingernails still.
Well,
That's why I'm like, I think I'm gonna grow the beard out because if I get anxious or anything, I'll just play with the goatee and the beard and won't take out my fingernails.
it's freezing in this little room that I'm in.
What's up?
It's absolutely freezing in this room that I'm in.
Yeah, I forgot to turn the heat on when I got home last night. I woke up and it was like 55 degrees in the house. I'm like, oh, I'm going to, but I couldn't fall asleep, so I came out here, took a couple Benadryl and put Oppenheimer on, and then I was out.
Nice.
So I forgot, I'm gonna re-up the Disney Plus when Andor comes out
Smart.
because
Let me know.
for some reason it popped up in my Spotify like, hey, you haven't listened to this in a while.
Oh,
Just went down the rabbit hole of the soundtrack, and I was like, I needed that show back like a year ago. So
Imagine how awkward this wedding would be if we hated each other.
It would be weird. That's why I'm like, well, I'm like, yeah, we're like, that's when Christine's like, are you guys gonna be together? I'm like, no, I thought about, I'm like, oh yeah, it's not like it's like witness intimidation or anything. Like yeah, I guess we could have done it together, but I'm like, you're at work, so it's like walk into your office, be like, hi everybody. Never met any of you. Never met any of you before. Well, you work with Logan and Keaton's sister?
Yeah. Yeah.
Oh my God.
Mm-hmm.
Which I didn't know Logan worked there until she made the post about the new doctor. That's how I knew about the new girl there. I was like, wait a minute, how does she know that? I was like, oh my gosh, she works with Logan too.
Yep. Good old Monroe.
Gifts. Well, I just ordered a pair and I meant to order two because I want to use the set for my.
I haven't even had a coffee yet today. I'm like, I should have gone up earlier and gone again Bigby or something.
Well, you can go get a coffee and bring me one after this.
Or do you want your hot caramel apple cider?
Yes. I've only had one so far this year. They're too expensive.
Yeah, I've been getting the White Lightning again, and I'm like, I hate that it's like $8 now.
Mm-hmm.
But I don't have coffee here, so I'm like, I guess I'll do it. But
yeah,
if I go in there, I'm like, oh, they have the caramel apple cider back. Like, what would Sarah do if I just brought one over?
I would be very happy. I would not object.
Right.
Hey, here's a little treat for us getting through today.
Yes, please.
Get ourselves a little snacky snack. Do you really want one? Or are you joking?
No, I really want one.
Okay.
Snack.
Are you sure you guys are getting a divorce?
I know,
We're
right?
sure. We're sure, but I mean, we're extremely we're civil. We're
still best friends.
We're still good.
Sounds like it.
Yeah.
We got dinner last night I was sitting there doing the math. I'm like, February, March, April, May, June. I'm like, oh my God, I haven't seen you in like 8 months.
That was a long time.
I've had nothing but water in this house. No coffee, nothing, just Aquafina.
So while we're waiting here, guys, I found a slight typo at the bottom of page 4. I don't know if you
Okay.
guys have your copies with you. It should say, if defendant is unable to refinance or assume the mortgage, all equity in the home would be hers.
Okay.
Right. If she's able to refinance, that wouldn't make any sense.
Right.
Store. Yeah, literally.
So I just added un before able.
Okay. Gotcha.
Thank you.
You're welcome.
I like saw that at first. So I'm like, well, that makes sense because like if you take over the house and like and it's yours and then you decide to sell it, like you would get whatever you sold it for after you had it for a while. So that made sense. But I guess it's just the wording's a little.
Yeah, if she is able, she gets all the equity in it. If she's not able, she still gets all the equity in it, which is how I understood you guys' agreement.
Yep.
Okay. No, wait. I'm sorry, this is my COVID muddled brain. The next page says, I think it was right the way it was, that you'll split the equity 50-50 if the refi or assumption doesn't happen.
Doesn't happen, yeah. And then
Correct.
Okay, all right,
Yeah.
then that was correct the way it was. I'm
Yep.
overthinking things. All right, sorry.
no, it's the Rona.
I'm gonna create issues where there are none.
Her and I both had like the original strain back in 2020, and yeah, we had COVID brain for a while, so we get it.
Thank you.
Can you talk about how that was the most miserable like 3 months of our lives, Sarah?
It was pretty bad.
Yeah, that original strain was awful. And I'm dealing with this now, having had COVID shots and boosters, and I just had a booster a month ago.
Okay, judges we're on record.
Okay.
Calling the matter of Jeffrey Gazinski versus Sarah Gazinski.
For the record, this matter is before the court for a pretrial conference. The same is being conducted via Zoom. Present is Attorney Christina Hills, representing the plaintiff Jeffrey Gazinski, and both parties appear to be present.
Yep.
Good morning.
Good morning.
Morning.
Your Honor.
Ms. Hills, have you had a chance to talk with the front of the court this morning, or would you like a formal mediation date?
No, Your Honor, we have an agreement. I actually have a signed judgment in front of me right now. It's been reviewed and signed by both parties. I'm prepared to put that on the record, the agreement on the record this morning. The parties have agreed that the judgment would be submitted after the first of the year so that they can file their taxes together for 2024.
Thank you, Ms. Hills.
You're welcome.
Before we begin, Ms. Sarah, do you understand that even though Ms. Hills is helping finalize this, she's preparing the written judgment divorce? She technically represents your husband, Jeffrey, and her loyalties lie with Jeffrey. Do you understand that?
Yes.
And you've approved a proposed judgment, is that correct?
Yes.
Did you approve it freely and voluntarily?
Yes.
You've had the chance to talk to an independent attorney if you chose to do so, correct?
Yes.
Okay. All right. The court's going to have Ms. Hill state what she understands to be the agreement. Listen carefully, Ms. Grzinski. Then after she does, I'm going to confirm with you that's the correct statement of your agreement, okay?
Okay.
All right, Ms. Hills?
Thank you, Your Honor, and bear with me this morning, please. A little under the weather. Your Honor, again, the parties have agreed that the judgment would not be submitted until after the first of the year so that they could file their taxes jointly for 2024. The parties have no minor children. So with respect to spousal support, that is barred as to both parties. We will include standard statutory language regarding life insurance. With one exception, each party is awarded the retirement benefits in his or her own name. Ms. Gerswinski is awarded, however, 100% of Mr. Gerswinski's Fidelity IRA ending in 8238 as of the date of transfer. The parties are going to attempt to facilitate that transfer using Fidelity forms, but if a quadro became necessary, they would use Ann Pastrana to prepare that quadro and split the cost of preparation as well as any fees charged by Fidelity. We've included COBRA language. If COBRA were required for either party, the party taking on COBRA benefits would be responsible for payment of that premium. The parties do have a marital home that would be awarded to Ms. Gerswinski, and she is going to assume all of the expenses of ownership, including the mortgage, any equity loan, utilities, taxes, and insurance, and will indemnify and hold Mr. Gerswinski harmless from those expenses. She is going to refinance or formally assume the mortgage on the property within 36 months of the date of entry of the judgment to remove Mr. Gerswinski's name from the mortgage and note. He will convey his interest in the property to her via quitclaim deed once he has been presented with proof of her pre-approval for refinancing or as needed for assumption of the mortgage or as required by any title company to accomplish the refinancing. And if she is able to refinance or assume the mortgage, then all of the equity in the home would be hers. If she is unable to refinance or to assume the mortgage within 36 months of the date of entry of the judgment, then the home would be listed for sale, and the net proceeds of the sale would be split equally between the parties. If the home is to be sold, then the parties would agree on a listing agent, a list price, any price adjustments, and the final sale price. Ms. Gerswinski is going to pay $750 per month directly to the mortgage lender. I'm sorry, I think that should be plaintiff.
No, that's
Mr. Gerswinski, you're going to pay the $750 directly to the mortgage lender. Is that correct? Mr. Gerswinski.
Sarah is paying the $750 and I am covering the rest of the 13.
Okay, sorry. So she is going to pay $750 per month directly to the mortgage lender each month, as well as paying the water bill until 36 months from entry of the judgment of divorce.
That's Jeff.
Yeah, and
Yeah, I think I don't think that's right. So Jeff is paying the water bill for 36 months, correct?
Yes.
All right. And Sarah is paying the $750 per month directly to the mortgage lender.
Yes.
Okay. Sorry, that'll need a little adjustment. Her assumption or refinance of the mortgage or the sale of the home, whichever comes first, that's 36 months. He is going to pay the balance of the mortgage owed each month, including any escrows for taxes and insurance. So there's a caveat essentially, Judge, to the her being responsible for those expenses related to the home, as I've just stated. And if you need me to restate those, I'm happy to do that because I know that was a little confusing. With regard to personal property, each party is awarded the personal property in his or her possession. Mr. Grzywinski is awarded the 2016 Chevy Malibu, along with any debt on that vehicle and standard hold harmless provision. And Ms. Grzywinski is awarded the 2024 Chevy Blazer, and she is going to assume and pay any debt on that vehicle and hold Mr. Grzywinski harmless from liability on that debt. Each party is awarded the bank and financial accounts in his or her own name. Each is going to be responsible for any debt in his or her own name. Parties acknowledge that I have not given any tax advice, and Ms. Grzywinski's maiden name of Tyner, Tyner, may be restored to her if she so chooses, and each would be responsible for their own attorney fees. And I believe that is the agreement. Again, if there's confusion on who's paying what, I'm happy to go back through that.
Thank you, Ms. Hills. But the both parties have approved the written proposed judgment. Is that correct?
They have, yes.
All right. And perhaps it wasn't necessary to recite everything since they've read everything. In any event, Ms. Sarah, do you have any questions of Ms. Hills regarding this agreement?
Nope.
All right, Mr. and Ms. Krasinski, can you both please raise your right hand to be sworn, please? Your right hand, sir?
Yep. The other right.
Do you both solemnly swear affirm that the testimony about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Mr. Krasinski?
Yep.
Thank you. All right, Ms. Hills, you can begin with Mr. Krasinski, please.
Yes, thank you, Judge. Mr. Grzywinski, state your name for the record, please.
Jeffrey William Grzywinski.
And you are the plaintiff in this case, correct?
Correct.
At the time you filed your complaint for divorce, had you been a resident of Michigan for at least 180 days?
Yes.
And of Monroe County for at least 10 days?
Yes.
Is it true that there's been a breakdown of your marriage relationship to the extent that the objects of matrimony have been destroyed and there's no reasonable likelihood that your marriage can be preserved?
Yes.
To the best of your knowledge, is Sarah pregnant?
No.
And you have no minor children together, is that correct?
Correct.
All right. And you've heard the settlement agreement
Yes.
placed on the record?
Yes.
Right. And you also read the proposed judgment of divorce consistent with that?
Yes.
Did you understand all of the terms?
Yes.
Have you had enough time to think about all these issues?
Yes.
Do you have any questions about anything related to the judgment or anything else about the case at this time?
No.
You understand that spousal support, or we also call it alimony, is barred as to both of you?
Yes.
And that means neither one of you would be able to come back into court in the future and ask for it.
Correct.
You also understand that by entering into the settlement agreement, you're waiving your right to any trial,
Yes.
contested hearing. All right. Are you satisfied with my services on your behalf?
Yes.
And are you asking the court after the first of the year to sign off on your proposed judgment and grant you a divorce?
Yes.
Thank you. I have nothing further.
Thank you, Ms. Hills. Ms. Sarah, will you please state your name and current mailing address for the record, please?
It's Sarah Elizabeth Stu.
Thank you. Did you hear the testimony this morning of your husband, Jeffrey?
Yes.
Was his testimony true and accurate to the best of your knowledge?
Yes.
Are you currently pregnant?
No.
Do you have any questions for the court?
Nope.
Do you have any questions for Ms. Hills?
No.
Ms. Hills, do you have any questions of Ms. Sarah?
No, Your Honor. Thank you.
Very well. The court would like to thank and acknowledge Ms. Hills for helping facilitate an amicable resolution between the parties. And Ms. Hills, the court hopes you feel better as the day goes on today.
Thank you.
The
I
court really
appreciate it.
appreciates your efforts in helping the parties. And the court applauds the two of you for reaching your own agreement. without question, the best resolution is one which you both participate and agree upon, rather than have the court decide these matters. Keep in mind, you will not be divorced till the court signs written judgment in January. Based, however, on the testimony that's been presented this morning, as well as the complaint filed in this case, court finds that jurisdiction has been established and that there has been a breakdown of the marriage relationship. Unfortunately, there appears to be no reasonable chance of reconciliation. Accordingly, upon receipt of the judgment in January of 2025, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved, and judgment shall enter, granting a divorce from the bonds of matrimony. Ms. Sarah, please be reminded that if in fact you choose to have your former name restored, you need to take that judgment divorce to the Secretary of State and Social Security to facilitate that after the first of the year.
Okay.
All right, with that, good luck to both of you. Thank you again, Ms. Hills. Hope you're feeling better.
Thank you, Your Honor. I appreciate it.
You can zoom out. Thank
All
you.
right, thank you.
Is that it?
Yep, that's it.
That's it. You can zoom out. Thank
right.
you. You put in your notes. Andrea, judgment to be entered, consent judgment to be entered in January. Okay, wonderful. I was on the phone with the insurance company.
Yeah,
God, this insurance is so,
I
I'm
know.
amazed. I'm trying to understand what co-insurance is. And of course, you know, the most frustrating thing, I had a question because I get a diagnostic code from U of M. I'm
Right.
trying to find out what is the allowable cost because the radiation is $3,500.
Right.
Trying to find what does Blue Cross approve, you know, because even like doctors, you see them and their charge is way up here, and Blue Cross approves
Right.
here. It's a network, so those providers will accept what Blue Cross pays. So I'm trying to get some idea what they will approve of that and what my copay will be. It's frustrating, but of course, you call the 800 number in the back of the Blue Cross card. It's a call center in the Philippines. This is John. This is John. For the record, this matter is before the court for a pretrial conference. The same is being conducted via Zoom. Sir, are you Jonathan Drum?
Yes, I am.
Joshua Drum? I'm sorry, Jonathan?
Jonathan Drum, yes.
All right, thank you. Is Allison Drum present? She needs to unmute herself.
Sorry, I'm here.
All right, you Allison Drum?
Yes.
Good morning.
Good morning.
Court is in receipt to be proposed to consent judgment of divorce, which is wonderful. And before we proceed, one issue needs to be addressed, and that is an issue of a filing fee. Mr. Drum, are you on public assistance?
I'm sorry, you were breaking up. Can you say that again?
Jonathan Drum, are you still receiving public assistance?
Yes, I am. I'm on EBT.
I'm sorry, you're on what?
I have food stamps, EBT.
Okay, are you disabled?
No, I'm not.
Okay, you just appear to be young, Mr. Drum. There's an issue that we need to address, and that's a complaint, a divorce filing fee of $255. The taxpayer should have to pay that. And if you are not going to pay that, I cannot order you to pay it, but I'm going to order that Miss Allison pay that $255, and I'll give you time to pay that.
Okay.
I thought that fee was waived.
The clerk waived that, yes. So we proceed with the divorce. And if you're still on public assistance, the court cannot order you to pay that, but I will order Allison to pay that. And the taxpayer should have to pay for this. Mr. Drum, you keep breaking up. Why don't you call in here because it's not a good connection. You don't have good internet. You keep breaking up.
Okay,
I'll call in.
Yep, I will call in.
Audio?
I'll call in.
Okay, you have the phone number?
Yes, I do.
Allison can talk about it in terms of who's going to pay the filing fee, but I cannot order you to pay it because you're on public assistance, but I will order Allison to pay that. And if you want to contribute toward that, and I will give you time to pay that, it's $255 due to the county clerk. But why don't you hang up, Mr. Drum, and call in so we have a better communication connection.
Do you have a pen and paper? I have the number.
Okay, I'll call in right now.
All right.
You have the number?
Yes, I do.
Okay.
Mr. Drum, just to hang on there. We're waiting for Jonathan to appear by audio, okay?
Okay. Sounds good.
Okay, Mr. Drum, are you present in audio now?
Yes, I am.
Much better. Thank you. Thank you. Again,
Sorry about that.
No problem. Courts have received the proposed judgment with which both of you have approved, which is wonderful. The only thing we need to address before we proceed is the filing fee of $255 to be paid to the Monroe County Clerk. Even though, yes, the clerk waived that, Mr. Drum, because you're in public assistance when you filed this. That's why the court asked you, are you still in public assistance? You said yes. So the court cannot order you to pay that, but the court will order Allison to pay that. And I'll give her time to pay that unless you volunteer to pay it. So Miss Allison, the two of you want to talk about it?
I just want to know what the date is to pay that.
I'd probably suggest 30 days. And I would write in the judgment that's due and payable by November 27th, which is the day before Thanksgiving. It's the last day the courthouse is open in November. And it's got to pay the county clerk, same place where you filed this complaint, Mr. Drum, 255, and it's got to pay in one lump sum. They won't take installment payments. And whoever's going to pay it, if you can't pay by November 27th, you can call the court and ask for this time. I'll give you additional time. You just don't blow it off. Because when you blow things off in the court order, then bench warrants could issue.
Okay.
Okay.
Okay, so Miss Allison, are you going to pay the 255?
Yes, I will.
Okay. Do you need a whole month to pay that?
Probably not. I'll get it done
Okay.
within the month. Yes.
Okay. So I'm going to write language in the judgment then, and I will initial anything I add to this judgment. I will initial next to it that defendant Allison Drum shall pay $255 filing fee on or before November 27th. Is that agreeable?
Yes.
Okay. Mr. Drum, if you want to reimburse her for part of that, that's totally up to you, but I cannot order you to do so. Okay.
Okay.
I'll add that to the judgment. All right, we can proceed to having it address that. And Ms. Drum, if something happens and you cannot pay the 255 and it's got to be paid in one lump sum, you can call and pay by credit card, but they're going to charge you, I think, 3% fee. You're better off just coming in with cash and save yourself some money.
Okay. Sounds good.
You go to the county clerk on the second floor, give them your case number and tell them you're here to pay a filing fee. If in fact you cannot pay by November 27th, you call the court and I will give you additional time. Just do not blow it off. If you blow it off, that's when bench warrants issue. We don't want that to happen. Okay.
Okay.
All right, Mr. and Mrs. Drum, can you both please raise your right hand to be sworn, please? Do you both solemnly swear or affirm that the testimony you're about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God?
I swear.
I swear.
Thank you. We'll start with you, Mr. Drum, because you're the plaintiff. Can you please state your name and current mailing address for the record?
Yep. My name is Jonathan Drum.
Thank you. Mr. Drum, is it true that you filed a complaint for divorce with this court on or about August 8th, 2024?
Yes.
True that on the date you filed that complaint, you had been a resident of the County Monroe for at least 10 days and the state of Michigan at least 6 months?
Yes.
Is it further true that you married Allison on April 5, 2017, you separated in June of 2021?
Yes.
Is it true there's been a breakdown of your marriage relationship to the extent that the objects of matrimony have been destroyed and there's no reasonable chance of reconciliation?
Yes.
Is it true there's only one child born of the marriage, namely Logan?
Yes.
Were there any children adopted during your marriage who are minors?
No, there was not.
Okay. I'm sorry, we lost Miss Drum, so we're going to just give her a minute to come back in. Oh, Miss Drum. Bless you. You need to
Okay, I'm
unmute,
so
Miss
sorry.
Drum. Okay,
I'm back.
did you hear any of the testimony of your husband this morning?
I did not hear. I'm so sorry.
All right, start over again. Mr. Drum, is it true that when you filed this complaint for divorce on August 8th, that you would reside in County Monroe for 10 days in the state of Michigan for 6 months?
Yes.
Is it further true that you married Allison on April 5, 2017, you separated in June of 2021?
Yes.
Is it true there's been a breakdown of your marriage and there's no chance of reconciliation?
Yes.
Is it true there's only one minor child of this marriage, namely Logan?
Yes.
Were any children adopted during your marriage who are still minors?
No, there was not.
And is it true that you signed your name to this proposed judgment approving the terms and conditions contained therein?
Yes.
Do you have any questions for the court?
No, I do not.
All right, Miss Allison, can you please state your name and mailing address?
Allison Drum, 15.
Thank you.
Ruby-
Miss Allison, did you hear the testimony this morning of your husband, Jonathan?
Yes.
Was his testimony true and accurate to the best of your knowledge?
Yes.
Are you currently pregnant?
No.
And did you also sign your name to this proposed judgment approving the terms and conditions contained therein?
Yes.
Yeah, I'm going to go through this judgment with both of you, the two of you, and that's the court applauds you for reaching your own agreement. Two of you have agreed that you're going to share joint legal custody of your minor child, Logan. Physical custody is awarded to the plaintiff father. Parenting time. There's no specific parenting time schedule. Can I just put in the words reasonable and liberal?
Yes, you can.
Yes.
And if in fact there's some problem with parenting time, you can always petition the court and the court can set a specific parenting time schedule. So the communication is key. Work together so that Logan spends as much time with mom as possible.
Yes.
Yes.
I'm going to write reasonable and liberal under the paragraph of parenting time, and I will put my initials next to that. The court has also checked a couple of boxes which are required, and I put my initials next to that. For example, the parent with physical custody, namely Mr. Drum, you must keep the Ms. Drum and the front of the court informed of any change of address, and you cannot leave the state of Michigan without approval of the court. You can't just like move to California because that affects mom's parenting time. And also you can't move more than 100 miles away without the consent of Miss Drum or the court. That affects parenting time. So I'm going to initial those boxes and put my initials next to that. Those are required. With respect to child support, you've referenced in the judgment that a uniform support order is not required because there's a pending case of 24-43069 here in Monroe County. Is that correct? That requires Allison to pay child support.
Yes, there is.
Okay, I need to complete the case number. Is that a DC or DS? Do you have that case number that you're currently paying support out of?
I do not. I'm sorry.
Mr. Drum?
I do not have it in front of me.
All right, we'll look for it then because we need to put some letters at the end of that, whether it's a DC or DS file. So child support will continue as previously ordered. Okay, spousal support is not awarded. That's forever barred. You've already divided your personal property. So each keep the personal property occurring in your possession. There are no joint debts. So each will pay debts in their own name. Each will keep their own automobile. There's no real estate to be divided. No retirement plans to be divided. And Ms. Drum, you're going to keep the name Drum. Is that correct?
That is correct.
Okay. Do you have any questions for the court, either one of you?
No, I do not.
Now you've been separated for a little over 3 years. Mr. and Mrs. Drum, there's a statutory waiting period in any divorce case in which there's a minor child, just to make sure there's no chance of reconciliation. It's a 6-month waiting period. It starts from the date the divorce complaint was filed. This divorce complaint was filed in August. So the 6 months expires in February of 2025. This court, however, has the authority to waive that. And I can enter the judgment of divorce today if you both agree and you believe it's the best interest of Logan to simply finalize things sooner than later, and so he can move forward. So, Mr. Drum, are you asking the court to sign the judgment of divorce today?
Yes, I agree to that.
Do you believe it to be in the best interest of Logan to finalize things sooner than later?
Yes.
Again, do you think there's any chance of reconciliation between now and February? Thank you.
I'm sorry, can you say that one more time?
Is there any chance of reconciliation between now and February?
No, there is not.
Right. Ms. Drum, are you also asking the court to enter the judgment of divorce today rather than waiting until February?
Yes.
All right, court will do so. And based upon the testimony that's been presented this morning, as well as complaint filed this matter, the court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed, and there appears to be no reasonable likelihood that the marriage can be preserved. Accordingly, it's ordered by this court that the marriage between the parties be dissolved and judgment shall enter granting a divorce from the bonds of matrimony. All right, that will conclude this matter. You can both zoom out. Have a good rest of the day. You'll both be mailed a copy of this judgment.
Thank you. Have a good day.
Welcome. You're welcome.
And
We're going to put you both in a breakout room just for 5 minutes.
Yeah, just 5 minutes for Mary Ann and Tim, Judge, to talk about a furnace is out and they need to agree that it can be fixed and where the money's coming from.
Do they need to zoom back into your office, Mr. Godfrey?
No, and then we'll put on the record because we're going to come back on December 9th, Judge, for our continued mediation.
I would actually like to zoom in to Mr. Godfrey's room with the opposing counsel.
All right.
Okay, once you both hang up then, and I'll take care of this other case with Mr. Godfrey, and then I'll be available until 12 noon, then thereafter after lunch hour till 2:30. So
okay, then if it's going to be that, if it's going to hang up the procedure, I will just.
It will not. It will not. No, why don't you hang up and then zoom back into Mr. Godfrey's office in about 5 minutes.
Judge, I think what Mary Ann is saying, zoom me into a breakout room with them through the court.
I gotcha.
All right?
Okay, we can do that. We're gonna put your breakout room there, put Mr. Godfrey in there as soon as he's done with this matter.
Thank you.
Okay, very well. Okay,
You need
thank
to
you.
join the breakout room. For the record, this matter is before the court for a pretrial conference. The same is being conducted via Zoom. Present is Attorney William Godfrey, representing the plaintiff Julie Estes. Ms. Estes appears to be present with Mr. Godfrey in his office. And sir, you are Lawrence Estes Jr., is that correct?
Correct.
All right, good morning. The court's in receipt of a
morning.
proposed consent judgment of divorce. Mr. Estes, before we begin, do you understand that even though Mr. Godfrey is helping put this matter together, he's prepared this judgment of divorce, he represents your wife, Julie, his loyalties lie with Julie. Do you understand that?
I do understand.
But you've approved this proposed judgment, correct?
Correct.
You did so freely and voluntarily.
I'm sorry?
Did you approve this freely and voluntarily?
Yes.
Voluntarily.
Voluntarily, yes.
Okay. No one's promised you anything or threatened you in any way in order to get you to approve this judgment?
Correct.
And you've had a chance to talk with your own attorney if you chose to do so, correct?
Yep.
Right. Can you both please raise your right hand to be sworn, please, Ms. Mercedes? Do you both solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Thank you. Mr. Godfrey.
Thank you. Speak up for the record.
Sorry,
Will you state your name for the record?
Julie K. Estes?
And you're the plaintiff in this matter, is that correct?
Yes.
And did you file a complaint for divorce in this matter?
Yes.
Were all of the allegations true at the time of the filing?
Yes.
Are they still true today?
Yes.
Were you a resident of the state of Monroe in the state of Michigan, county of Monroe, at the time for at least 180 days immediately preceding the filing of the complaint?
Yes.
Are you pregnant?
No.
Do you have any minor children?
Minor, no.
Were there any children placed for adoption?
No.
You have gone through this consent judgment of divorce and your signature appears on that. Is that correct?
Correct.
Are you asking the court to approve it?
Yes.
Is there any chance that this marriage can be reconciled?
No.
So the objects of matrimony have been destroyed and there remains no reasonable likelihood the marriage can be preserved.
Correct.
And you're asking the court to approve this consent judgment of divorce.
Yes.
As part of this judgment of divorce, you are giving up your interest in a parcel of real estate that you and your husband own, Creek Road, Monroe, Michigan. Is that correct?
Correct.
And you have signed a deed, a quitclaim deed that I am holding, and that will be released upon the happening of the payment of $97,500 to you and verification that you're off on the underlying debt of the property. Is that correct? And upon either a closing or payment and verification of that, I will release the deed for recording to your husband or to a title company or to a bank.
Correct.
Do you have any questions of me?
No.
I have no further questions of my client, Judge.
Thank you, Mr. Godfrey. I apologize if you asked this question. Ms. Estes, are you currently pregnant?
No, I am not.
Thank you. Mr. Estes, can you please state your name and current mailing address for the record?
Lawrence Douglas Estes Jr.
Thank you. Mr. Estes, did you hear the testimony this morning of your wife?
I did.
Julie? Was her testimony true and accurate to the best of your knowledge?
Yes.
Do you have any questions of the court or any questions of Mr. Godfrey?
I do not.
Do you believe the property settlement set forth in this judgment is fair and equitable?
Yes.
All right, Mr. Godfrey, do you have any questions of Mr. Estes?
Mr. Estes, just be aware that I'm holding that document, so keep me in the loop where I need to release that quitclaim deed to. If it's going to be a title company or a bank or whatever, I need a little lead time on them.
Yes, sir.
I have nothing further, Judge.
Thank you. The court would like to thank and acknowledge Mr. Godfrey for helping facilitate amicable resolution between the parties. And the court would applaud you, Mr. Estes, for reaching your own agreement. Without question, the best resolution of matters of this nature are ones in which you both participate and ultimately agree upon. Far better off than having the court decide these matters. Based, however, on the testimony that's been presented this morning, as well as the complaint filed in this case, court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there appears to be no reasonable likelihood that the marriage can be preserved. According to it's ordered by this court that the marriage between the parties be and is thereby dissolved and judgment shall enter granting a divorce from the bonds of matrimony. The judgment has been signed. Good luck to both of you. You can both zoom out. Have a good rest of the day.
Thank you.
Judge.
Thank you.
You too.
Welcome. parties have engaged a good part of the morning with the attorney William Godfrey this morning. So present are both the parties, as well as plaintiff's attorney Timothy Churchill and defense attorney Mary Ann Kirschbaum. Mr. Godfrey, the parties made any progress toward resolution of these outstanding issues?
Judge, I put this on relatively quickly on my docket for the parties, and we're going to need a continued mediation date, and I'm thinking we're going to need till, I'm putting it on my docket for December 6th, starting at 8:30 in the morning instead of 9, and then do a pretrial subsequent to mediation on the same date with the court's permission. They need additional discovery needs to be done. We only had a partial appraisal. The full appraisal was not completed, or the retrograde appraisal was not done. There's additional bank statements that the parties are going to try to assemble, and hopefully put a summary of expenses together in a way that I can follow it a little easier. Again, we pushed the parties trying to get this today. There is one agreement that there is a furnace that needs to be replaced at the property at 3162. That cost can be paid out of funds that Mr. Churchill is holding in his client's trust account from a sale of the rest of the funds would remain pending further order of the court. There's approximately 107,000, a little over that Mr. Churchill is holding. The furnace replacement should be no more than 10 grand, and that can be done. And then we'll figure out how that is allocated at the next mediation or reserved for the court. That is done. I need more information on the real estate, and I'll put that in what I need from the parties in my summary letter. But we'll come back then with the court's permission. The pretrial would be after that.
Well, that date is fine with the court. That works with your schedule, Mr. Churchill and Ms. Kirschbaum?
Yes.
I'm so sorry, Your Honor. It was a little muffled. Would you please repeat that?
The date of December 6, 8:30 worked with your schedule and that of your client?
Yes, absolutely, Your Honor.
The court will be available that date, so whenever you're done with the mediation, you can zoom into the court. The court will mail out notice that we continue a pretrial conference on December 6, 2024, subsequent to the 8:30 a.m. mediation with Attorney Godfrey. We'll again provide you Mr. Godfrey's Zoom ID number.
My secretary will send it out, Judge.
Right, thank you. Who's going to initiate this appraisal that Mr. Godfrey referenced?
I already have a commercial appraisal. The appraiser that misunderstood our direction as to what the nature of the appraisal job was. So I have all that taken care of, and we'll have the rest of it done.
All right, and hopefully the parties will complete the remaining issues of discovery prior to the December 6th continuing mediation date. Is that correct?
Yes, Judge.
Yes.
The last thing I would add, Your Honor, the motion that's been filed is going to be held in abeyance at this time. Do we see if we can resolve this through mediation?
And that is correct.
Thank you. The court would prefer that. Thank you, Mr. Kirschbaum and Mr. Churchill. The court will hold those motions in abeyance. Pending, the court will be optimistic that the parties with Mr. Godfrey's assistance can reach a full and final resolution on December 6th. You want to put a partial agreement on the record, is that correct? You want the parties sworn, Mr. Kirschbaum and Mr. Churchill?
I don't think, Judge, we need that. It's understood by the attorneys that the 10 grand can come out of that, or the replacement of the furnace can come out. We don't have to get everybody sworn to that.
All right.
As soon as they give me an invoice, I'll just pay it directly to the company, so I'm not transferring it to my client or anything.
Yeah, that's going to be paid to American Heating and Cooling.
Right.
And you'll provide Ms. Kirschbaum with a copy of the invoice?
Yes,
and receipt, correct? All right.
Yep,
Is there
certainly.
anything further for the record this morning then, Mr. Churchill?
No, Your Honor.
Ms. Kirschbaum, anything for the record this morning?
No, Your Honor.
All right, the court would like to thank and acknowledge Mr. Godfrey for his availability this morning, as well as the parties' participation in this mediation. Mr. Oberhu and Mrs. Perez, without question, the best resolution of matters of this nature is one in which you both participate. You're both represented by capable family law practitioners. Keep an open mind and try to reach your own agreement as opposed to throwing things up there and have this court decide. So with that will conclude this pretrial conference. Court may allow notice, continued pretrial, subsequent to the 8:30 a.m. mediation with Mr. Godfrey on December 6th. And that will conclude this hearing. So everyone can zoom out. Have a good rest of the day. Thank you, Mr. Godfrey.
Thank you, Judge. I'll send my letter out to the party.
Okay.
Thank you.
Thank you, Bill.
Thank you.
Thank you, Your Honor.
You're welcome.
Have a good day.
Present with Mr. Churchill. In addition, Attorney Mary Ann Kirschbaum is present, representing the defendant Julie Perez, and Ms. Perez is also present. Good morning, everyone.
Morning, Judge.
Morning, Judge.
Mr. Godfrey, have the parties been able to reach their own agreement with your assistance this morning?
I think they have, Judge, and with the court's permission, I'll place it on the record.
Please, Mr. Godfrey.
Thank you. We start with the real estate. There was one parcel of property, and I'll go through each parcel separately. There was one parcel of property at 6886. This was inherited by husband. It was subject to litigation, and ultimately that litigation was resolved with a payment of $27,500 going to husband, and husband issued a deed, I believe, in lieu of foreclosure. So there's no longer any interest in it. But I wanted to mention that because there had been money that came in, $27,500, and that money is all spent. But I took that into the account in the global settlement. The second parcel of property, again, this property is going to be awarded to wife. That had been in husband's name, but there had been a quitclaim deed putting it into a couple of other people's names. Whosever name that is, there will be a quitclaim deed transferring that property before year end to wife. Wife will get keys to that property no later than December 22nd of 2024. Utilities to that property need to be read, and that can be read next week. And whatever the balance owed at that point in time, husband is responsible for payment of that. The utilities then need to be placed in wife's name if they have not already in wife's name, but husband thinks they are, wife thinks they are in her name, husband thinks they're in his name. But at the end of the day, they got to be put into wife's name. We're trying to do this without shutting off and getting a reconnect. It just read and transferred into the other person's name. There is unpaid real estate taxes on this property. The summer 2024 are unpaid. The winter that just came out obviously have not been paid. Those would be wife's responsibility for payment of. There is a current listing agreement with Caldwell Banker. I believe Tom Fritz is the broker on that one, or the listing agent. That would be canceled. The property is vacant other than some personal property that Mr. Overhue husband has there, which he's going to remove on or before that December 22nd, 2024 date. That deals with the South Monroe Street property. Parties, do they have any questions concerning that, or attorneys?
No.
All right, Mr. Churchill will be preparing that quitclaim deed. And that can be signed and immediately forwarded to wife's attorney, and they can deal with the recording of that and any other lien that she needs to put on it for protection of attorney fees. All right. Husband is awarded 3778. Wife may remain at that property and vacate that not later than January 31st of 2025. When she vacates that property, all utilities, streaming services, or whatever is there needs to be in a husband's name. If they need to cooperate with that between each other, they should do that. All utilities, husband is responsible for at that property. Husband also had a property at 213 Short Street, Northwood, Ohio, 43619. That has been sold. Funds are being held in Mr. Churchill's client's trust account. Those are all released to Mr. Churchill and husband. At the mediation today, the balance was $96,709.19, and that was after a furnace repair for the Lake Shore Drive home had been made. But those all remain with the husband. Wife has 2 rental properties that are awarded to her, and they remain as her sole and separate property. Those properties are located at 21. Both of those are duplexes. For 2024 tax returns, the parties are going to be divorced. Wife would be picking up any of the rental income from the East Pearl Street properties, both of those on her return. Husband picks up any rentals or sale issues dealing with property that I've mentioned, dealing with that Short Street. Any of that is husband's responsibility. Anything dealing with Lake Shore Drive is husband's responsibility. There was no rental income from the South Monroe Street property, so it's just whether or not wife can take any deductible expenses dealing with that, but she can if there is anything for 2024 on the South Monroe Street property. So if there is depreciation or taxes write-off or insurance write-off, she can claim that on her return. If she can, no attorney here nor this mediator is making a representation dealing with the tax advisability of that. That's going to be up to their own tax preparers. That is the real estate. Any questions by the parties dealing with the real estate?
Ms. Kirschbaum?
I have a question, Mr. Godfrey, but it deals with the streaming services. Did you already go over that?
I will talk about that under miscellaneous.
Okay, thank you.
All right, that's my 12th topic or 13th topic. All right. After the, Mr. Churchill, any questions on the real estate?
No, since Ohio has dower laws and that, if they need a deed from us, we'll give them a deed on parole, although we were never on the chain of title to begin with on that one.
All right. Maybe the judgment is sufficient to merely state that under the releases any dower interest in the state of Ohio on Ohio property. That I think would be sufficient.
Okay.
Just include that in the judgment. Automobiles, wife is awarded the 2010 Buick as well as a 1984 boat. Husband is awarded the 2025 Chevy Trax. Each party is responsible for any expenses, plates, tags, anything on the items that they have been awarded, and they will hold the other party harmless from any liability thereon. Bank accounts have already been separated. Each party would keep their own. There is no retirement. Personal property. Ultimately, the parties would arbitrate any personal property dispute. If there is a dispute, that is to be referred to binding arbitration no later than request of February 1st of 2025. Absent a contrary agreement of the parties, I would act as the binding arbitrator. The sole role of the court would be to enforce the award of the arbitrator. The parties cannot go back to court requesting a separate or different division. Sole role is to follow whatever the arbitrator puts in the award. The cost of the arbitration would be shared 50-50. This would be without attorneys, so that the sole cost would be sharing the cost of the arbitrator. There are some specific items of personal property that are being awarded to wife that are at the home on Lakeshore Drive. Those items consist of the following: a brown suede / leather couch that is on the porch, the dresser that is on the porch, 3 end tables that I've defined as a round wooden table, one that is next to husband's bed, and a child end table that is on the porch. In addition, there's a marble top table, the guest bedroom bed. If the jewelry box of wife's is located, that is to be turned over to wife along with the contents. Mr. Overhue does not know where that's at. If there's any items at Noah's house, he will go through that and do a thorough search to see if it can be located. And again, if it is located, it would be turned over to wife. There is a refrigerator, a new refrigerator at the marital home, and that is awarded to wife, but not the contents. So they need to coordinate the arrival of a new refrigerator by Mr. Overhue, and then the removal of the current one. And hopefully that can be done in the next week or so, where Mr. Overhue goes out and gets another refrigerator, and then they can coordinate that getting moved to the Monroe Street property, if that's where wife wants it to go to. The 2023 tax return has already been filed, and that is taken care of. There was a City of Toledo tax liability that dealt with rental properties in Toledo, Ohio. Those are going to wife, and I don't know if that's still outstanding, the 2023 tax liability, but it was relatively small, $371. If there was any estimated payments for Ohio, those would stay with wife as to her Ohio property. Health insurance, each party is responsible for their own health insurance coverage post-divorce at their own expense. If either party had incurred any medical procedure that was not covered by insurance, each party is responsible for payment of their own uninsured medical expense. Attorney fees, each party is responsible for their own attorney fees and or costs. Spousal support is barred as to each party neither party may ever come to a court requesting spousal support. Under miscellaneous matters, the parties need to make sure that their car insurance has been split so that the insurance on the Trex is only on husband's name and the insurance on the Buick or the boat is only in wife's name. There is there is a phone plan that is on wife's daughter's plan. Each party needs to separate that so that they have their own plan. And Mr. Oberhue will need to get that taken care of with Amber. I believe there's an outstanding bill with Amber of approximately $300. And any bill with Amber, that's got to be paid for as to each party's own phone, but Mr. Oberhue apparently owes some money to Amber. There are no streaming services that are joint, so whoever has a streaming service, if they want to keep it, they take it with them, or if they have it, they cancel it. Mediation fees would be paid for by husband. That would be for the last mediation and this mediation. So that would be coming out of the funds that Mr. Churchill was holding. There was a payment to a wife out of those funds previously of $10,000, but that was already taken into account and that isn't going to be repaid. So there's nothing to be repaid out of funds that have already been distributed. This resolves all pending motions, matters involving the court. There's nothing remaining, so we don't have to worry about disqualification of Mr. Churchill. This is all done. Mr. Churchill will prepare the judgment and he'll prepare the quitclaim deed for the Michigan property. And I'm not an attorney in Ohio, but if Ms. Cosbaum figures out that they need something for Ohio, just prepare that for husband's signature. I don't think so. I think the language in the judgment terminating the dower is sufficient. That's the agreement, Judge.
Thank you, Mr. Godfrey. Mr. Churchill, did Mr. Godfrey accurately state your client's agreement?
Yes, except one issue I need further clarification on. Ms. Perez had previously removed Mr. Oberhue from the phone plan that she had in her name. He did get his own cell phone a month or two ago when he found out his old one didn't work anymore, and we didn't know anything about any bills on it. And I don't think we didn't discuss this at mediation exactly. I don't know anything about an outstanding bill on it, but when he was cut off, he didn't use it anymore. And Dean's saying he doesn't think he should. He's been paying for a new phone since.
Yeah, the other thing is that I told her if there is a bill due, whatever, I said I would like a copy of it. She sent me some email and all it says is device charge. Well, what's a device? I mean, it doesn't say self. Well, how do I know? How do I know it's not some internet service or whatever? It just says device charge. I don't care. I would like specifically for it to show cell phone balance and whatever. So it's not showing. It's not clear.
Just contact Amber and have her give you the.
And as far as I'm concerned, this is between me and Amber. Has nothing to do with the divorce.
I just wanted to, yes, thank you. I guess my response is, are you saying that the bill itself has been provided to you and the bill itself just says device?
Yes.
Okay,
that's
then.
Exactly what I'm saying.
So the only thing that can be done is you can call that company and ask.
I'm not allowed to because the account is in her name, and anytime I call them, they tell me I cannot get information on an account that is not mine. So therefore, she has to get me the information that shows that. Now, again, as to where this becomes part of the divorce, I don't know, because this is Amber, her daughter. I didn't marry her daughter. I'm not certain how you can involve this in the divorce or why.
Mr. Oberhu, perhaps we can provide some sworn testimony this morning from Ms. Perez. Ms. Kirschbaum?
What I was gonna say is my client can't make a company make a bill the way she wants it or the way he wants it. What I'm suggesting is that my client can have call on speakerphone, call the phone service, the carrier, and she can put it on speakerphone when husband's there, and they will confirm what that charge is for.
This isn't an account that's under my wife's name. You understand that?
We're talking about Amber. You can go with Amber on a Saturday, since you've been giving Amber such a hard time. All you gotta do is give her $300 to pay off your phone. You didn't do things right when you went to try.
I don't have a proper statement on my thing. I just told her, run me a copy of the bill. That's all I ask, and give me a paper bill, run it through a copy machine. I don't do well with email. I want a record. I need a record.
On a Saturday with her and stop arguing about this. Let's move on.
Right, just run me a copy of the bill. I'll through the photocopy. She's got a copy machine. That's all. That I'm old school. That way I can write on there, paid check number so and so, have it in my file, and I've always got it. That's how I do my records. I work with copies, invoices. I don't just.
Anything else? I think we can get that from Amber.
Yeah, that's all I ask her that several times, and she doesn't give it to me. Instead, she wants me just to give her money, and then I have no record of. I can't write on the invoice. Hey, listen, I'm
okay. Hold on, Mr. Oberhu. We know what you want. You made it clear a couple of times, Ms. Kirschbaum. Do you have any suggestions?
Well, Amber is in very bad shape with her cardiovascular, her cardiac problems right now. So that's what my client was trying to say about why Amber may not have been as responsive as you would have liked her to have been. But I also know there's some money that Amber has been paying streaming services for, I don't know what, Netflix or whatever is in your home, and she just needs
No, we're not going through this. She ordered that. Her mom did. I don't use.
But it can be canceled. It can be canceled immediately.
Yeah, no.
But I'm not paying any of these other bills. I'm not going through paying Amber's bills.
Amber's giving it to you for free. We're not talking about that.
Your attorney says there's Netflix.
It's just going to be canceled. That's why I said the streaming services can be canceled.
Okay.
Okay.
But he's not responsible for payment of the screening services if they're on the bill.
They're just
That's
being
why he wants
canceled.
to see a bill. Okay.
Right.
Provide us a bill and he'll pay his share of the phone.
Is that acceptable, Ms. Kirschbaum?
That's fine, Your Honor.
Yeah,
So repeat.
send me a bill.
Mr. Tricia, repeat that again. So once he receives a written bill, then he'll pay his share. Is that correct?
Yes, for phone service charges, not streaming charges that he didn't order or know about till today.
And how much is this? How much is this bill she's claiming I owe?
$300. We've spent more of that right now talking about it.
Yeah. Just
Okay.
I'll
Okay.
be prepared.
Anything else?
Okay.
Anything else by the attorneys on what I placed on the record?
Do you know what your mediation fees are, Bill? I can take
I
care
will
of
call
that.
you after. I do not. I know what they were from the first one, but I do not know on this one yet.
Just let me know when you know the total.
I will.
Pay it from the trust funds. Okay.
So let's go back to this issue about this phone bill and $300. Mr. Godfrey, what's your understanding of the agreement?
The understanding is that upon proof of that $300 is for the phone device that Mr. Oberhu had, he'll pay that.
Okay. Is that acceptable, Ms. Kirschbaum?
Yeah, he's going to have to just accept. Excuse me. He's going to have to accept that the word device is going to have to be good enough.
Well, he wants a written statement. I mean, is there a problem getting him a written statement?
Well, of course, we're gonna give him the bill, a copy of the
Okay.
bill, but if the copy of the bill just says device, generically just says device, he's just gonna have to, that's gotta be good enough for him.
It
Well,
should
does the bill
identify
reference
it
a
with a
phone
phone
number?
number.
As long as he just wants to know he's not paying all these streaming charges.
No, he's not. That's a totally different.
Presumably, the bill will reference a phone number, correct?
It should.
That should indicate it's a phone bill, not for some streaming service.
Right, and it wouldn't even be the same company.
Right.
Because
Right,
one
right.
company's a phone company and one company's like Netflix or something
Who's
else.
the provider for that particular phone? Is it Verizon?
Yes.
Verizon.
All right, so it should be a bill from Verizon. Verizon
Yeah,
does
he
not
can just
provide
go with
streaming
Amber on a
services.
Saturday.
So, Mr. Churchill, Mr. Oberhall will be provided with a statement from Verizon, which will reflect that phone number. Verizon does not provide for streaming services, as far as this court knows.
Well,
So
this
that'd be
doesn't,
acceptable then? Mr. Churchill, if your client receives a bill from Verizon showing that?
no. I mean, what?
I don't know what's on that bill. If it's a phone charge, yes, he'll take care of it. If it's a screening charge, no, he shouldn't have to.
I don't think there'd be any streaming charges on a Verizon phone bill.
Correct. You could walk in with Amber to any Verizon store and they will clarify it. Just arrange on a Saturday to go to a Verizon store and they can pull up that bill and definitively tell you. It's pretty simple.
I just explained to you, Bill, I can't because the account is not under my name.
No, you go with Amber.
Oh, well, yeah, if Amber goes, yeah. Amber
Okay,
can do that.
Will Amber cooperate with Mr.
Yes.
Oberhu and go to a Verizon store?
Yes.
Okay, that takes care of that then. So, Mr.
Okay.
Oberhu, just reach out to Amber, schedule a Saturday to go into a local Verizon store, and they can clarify everything, and then upon that, you can pay the $300. That's paid to who, Mr. Godfrey?
That 300 is paid to Amber.
What?
Okay, is that agreeable, Mr.
Be paid
Churchill?
to Amber, not Julie.
Oh, yeah, I mean, this is between me and Amber. It's not, doesn't have
Okay.
anything to do with Julie.
Well, it's part of this agreement, Mr. Oberhu. You're willing to pay the $300 to Amber once you are satisfied that it's a phone charge.
Okay.
All right, Mr. Oberhu is acknowledged. That was part of this entire global agreement. All right, Mr. Godfrey, you can continue.
I think I'm done, Judge. Just swear them in, and I'm not sure if proofs were taken in the past, but they're
It
ready.
was. Yes, proofs were taken in August, so we simply have to update those to verify that Ms. Press is not currently pregnant. Right, Mr. Kurzbaum, did Mr. Godfrey accurately state your client's agreement?
Oh, yes, this represents everything we've agreed on.
Thank you. And the court would note that when we were last before the court, October 25, the court did hold in abeyance your motion to disqualify Attorney Churchill. Are you now withdrawing that motion?
Yes, Your Honor.
All right, thank you. So let's note for the record to clear up this file. All right, to Mr. Oberhu, Ms. Perez, can you both please raise your right hand to be sworn?
Right hand aloft.
Right.
Do you both solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Yeah.
Thank you. Mr. Churchill, you can begin with Mr. Oberhu, please.
Okay. And again, we previously put proofs on, and again, your knowledge, your wife is not pregnant, correct?
Correct.
Okay. Dean, you've heard the settlement that's been placed on the record by Mr. Godfrey. In fact, does that reflect your agreement for resolution of this matter?
Yes.
Do you think that, or do you feel that represents a fair and equitable full division of the marital property?
Yes.
Okay. And you realize had you proceeded to trial, you perhaps would have received more or less property.
Yes.
But nevertheless, you agree to be bound by the provisions of the agreement that was stated on the record today.
Yes.
You're doing so freely and voluntarily, your own volition and free will?
Yes.
Okay. And you understand the settlement that you've reached?
Yes.
Okay, thank you.
Thank you, Mr. Churchill. Ms. Kurzbaum, do you have any questions, first of all, for Mr. Oberhu?
No, not for Mr. Oberhu.
Okay. Questions for Ms. Perez, if you can please begin by confirming that she's not now pregnant.
Yes. Ms. Perez, are you currently pregnant?
No.
Did you understand all the terms of the settlement?
Yes.
Do you agree with those terms?
Yes.
Do you feel the settlement was fair and equitable given all the circumstances?
Yes.
You understand that you cannot change the settlement agreement? Okay, it's final. You are getting no spousal support, nor are you paying any spousal support. You understand that spousal support for both parties is forever barred.
Yes.
And you can't go back and ask the court for spousal support.
Right.
Okay, and again, you understand that you had the absolute right to go to trial in this matter, and are you waiving that right?
Yes, I am.
And you understand that you had the absolute right to request spousal support in this matter. Are you waiving that right?
Yes.
Okay, thank you.
Mr. Churchill, do you have any questions of Ms. Perez?
No.
Judge, I do.
Mr. Godfrey.
Ms. Perez, during the course of this mediation, I inquired if you had any lottery winnings, and you indicated that there are none. Is that correct?
No.
No, you have to say yes.
Oh.
Is that correct, that there are no lottery winnings out there?
Yes, there's none.
All right. That's all I needed verified, Judge.
Thank you, Mr. Godfrey. And the parties will be divorced in 2024. Is that correct, Mr. Godfrey?
That is correct, Judge. Mr. Churchill has to crank this out and get it to your honor and approved by the end of the year.
Very well. The court would like to thank and acknowledge Mr. Godfrey for his fine assistance in helping the parties reach their own agreement. The court would also like to thank and acknowledge Attorneys Churchill and Kirschbaum for their assistance. And the court would applaud the two of you, Mr. Oberhauer and Ms. Perez. Without question, the best resolution of matters of this nature is one which you both participate, as you have this morning, and reach your own agreement. Far better often have the court decide these matters. Based, however, on the testimony that's been presented this morning, as well as previously, the court again finds that jurisdiction has been established, and there's been a breakdown of the marriage relationship. There's no chance of reconciliation. According upon receipt of the consent judgment, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved. The judgment will enter granting a divorce with bonds of matrimony. That will conclude this hearing. Everyone can zoom out. Have a good rest of the day. Thank you, Mr. Godfrey.
Thank you, Judge.
I'll tell you what, sometimes I'm struggling trying to fit people in. Like I had a guy with an emergency motion. I was like, I don't know where I'm gonna put you. How emergency is this? Yes. How emergency is
Well, some attorney, everything's an emergency. I mean,
Yeah,
this right here. You see right here, emergency motion.
Yeah. Right.
It's not an emergency. It's not like the child's in danger. No, it's a DO case.
Exactly. They just want it. Yeah, exactly.
Good morning, Ms. Hicks.
Morning, Your Honor.
How are things?
Good. How are you?
I ask you, what is Lincoln going to be for Halloween? Action character or what?
No, some kind of character that has this white mask and they wear a black hoodie and black sweatpants, so it made it easy for me to get a costume for him.
Okay.
There you go.
Okay.
Yep.
We are ready when you are.
Okay. I'm going to start with the bench warrants to cancel first.